Now moving on to tenure arbitration decision. In the matter of the tenure arbitration of Coleman, again, this is a teacher tenure matter where the employment of the teacher is at issue, and tenure charges were brought against this teacher who is alleged to have made inappropriate social media postings, and there was a big negative community response to this posting. So tenure charges were brought against this teacher, and of course there's always the First Amendment rights versus the duties of the teacher. So that came down to the commissioner in this case said, regardless of whether the teacher was exercising her First Amendment rights in sharing this post, the actions in doing so, and then her shifting excuses thereafter, which came out during the hearing, constituted conduct unbecoming. Ultimately, her removal was sustained, and as well as the tenure charges. They found aggravating factors included consequences to the district and the lack of remorse. So in this case, they found that it went above her First Amendment rights to do so, and that this impeded her ability to do her job, for the students to have to be able to respect her and to be able to see to her as a teacher. And that they found that ultimately her removal was upheld. In the matter of the tenure arbitration of Janicki, this is a matter that involved both an increment withholding and tenure charges. So first we have the increment withholding matter that occurred prior to the filing of tenure charges. There was an arbitration on the increment withholding before the tenure charges had been filed. So the arbitration award was issued, and the increment withholding was upheld. Now the district thereafter wanted to request to amend and make supplemental charges to include information that was tied to the arbitration. And in this case, the arbitrator granted the respondent's motion to dismiss, saying that to allow a district to amend or supplement the charges of the increment withholding would be inconsistent with Teach NJ, because the increment withholdings do not fall under Teach NJ, and that should not have been allowed to have happened. Moving on to some special education matters. First, we have JS versus Wayne, which came out of the Office of Administrative Law in July of 2021. In this case, the question was whether a 21-year-old was an eligible student for an out-of-district placement. The student had a signed IEP that required the student to transition out of district services due to aging out. But then we had COVID, and we had Senate Law 3434, which was signed, and the petitioner filed for emergent relief and due process to enforce a stay put provision of the IEP for continuation of an out-of-district placement, and that requested emergent relief was granted. That student, because they were just at the time of aging out, but it was during COVID, when did ask for a stay put provision to be enforced, and they were granted that. Again, that was only emergent, that was only done for a certain amount of time, but it did give the parents then enough time to go forward and try to seek additional services for this student. LB versus Edison, August 25th, 2021. In this case, we had an eligible student that moved to a district in January of 2021, via an out-of-district placement until COVID closed, everything down. And at that point, the student didn't use some of the services because obviously the schools were shut down. In spring of 2020, or after the child study team meeting in 2020, the student had aged out, but again, hadn't gotten those services in between. The administrative law judge found that FAPE, to the greatest extent possible, was provided at the time. So the district did everything that was possible at the time. And just because certain things weren't available during COVID doesn't mean that the district wasn't still delivering FAPE. The fact finder, in this case, there was a good piece of advice. The fact finder should factor what the LEA believed was feasible at the point in time the alleged FAPE was denied, rather than looking solely at what the LEA could have done. So in this case, the judge did give great deference to the district, found that they were doing as much as they could, or as much as any other district could have done during COVID. And just because everything on that piece of paper, on that IEP, was not being done at the time, the district was doing everything that was feasible at that particular point in time, which was a very odd point in time, not something hopefully we ever have to deal with again, but said you have to look at the point in time and not just what exactly is written on that piece of paper. That brings us to the conclusion of our presentation. Attached is our contact information. I am listed there, Kathleen Nasher, Senior Manager, Legal and Labor Relations. We also have on staff John Burns, who many of you have spoken with, is our Senior Legislative Counsel, and Katrina Homel, our Legal Counsel, who are part of our Attorney of the Day service. So if you have any questions, there is always someone assigned each day to discuss legal information with you. You can email us at any point as well, and we are happy to give you whatever information we can. Again, your board attorney is always, always, always your best resource and the person that will be have to be your go-to for official legal advice. We are not able to give you official legal advice, but hopefully we can direct you to something that can help you. You can always follow our school board notes for any cases that come out that are particularly relevant. We will get those to you that way and through your continuing training. But with that, that is the end of our Governance 4 presentation. I hope you have enjoyed this presentation, and we thank you again for your service and for all that you do for the students of New Jersey. Take care.